It was the day of reckoning for Kiambu Governor Ferdinand Waititu, his Samburu counterpart Moses Lenol Kulal, and Nairobi Governor Mike Mbuvi Sonko, who sought to find out whether the appeal to reverse the ruling barring them from accessing their offices would go their way. At around 9 a.m. Friday, in stepped Appeal Court Judge Jamila Mohammed, who gave her assessment of the matter before giving her orders.
The learned judge, Judge Mumbi Ngugi, declined to exercise the court's powers of revision over the decision of the trial court and instead determined that in the public interest, the bail terms pertaining to access to the county offices by the appellant for the duration of the trial should remain in force.
Judge Mohammed also sought to clarify Judge Mumbi Ngugi's ruling regarding the tenure of the accused governors.
The governor in this case is not being removed from office. He has been charged with an offense under the assessor and in my view, a proper reading of section of the act requires that he does not continue to perform the functions of the office of governor while the criminal charges against him are pending.
According to the ruling by the trial court, if governors were to access their offices, then conditions must be imposed that protect the public interest, with the High Court upholding that the trial court was entitled to apply the bail terms it did.
Given the aforegoing, our view is that the allegation that the imposition of bail terms barring the appellant from the county offices was tantamount to a removal from office is therefore unfounded. As such, we agree with the High Court that application of section 62(6) was unnecessary and the learned judge was not compelled to apply that provision to the circumstances of this case. Of greater relevance, perhaps, is the question of whether the bail terms that barred the appellant from office or subjecting the county government to the control of EACC was reasonable.
Appeal Court Judge Mohammed revealing that the law was followed in its entirety. Thus, the appeal lacked merit.
Likewise, we too are satisfied that both courts below properly exercised their discretion when they took into account the appropriate principles or guidelines on bail. Further, we can find no wrong in the two courts' application.
And regarding the appeal to revise the ruling,
we respectively agree with the learned judge's holding, and we have no basis of faulting her in any way. In conclusion, therefore, we find this appeal devoid of merit and dismiss it in its entirety. The appellant shall bear the costs of the appeal. It is so ordered.
Meanwhile, Director of Public Prosecutions Nurdin Haji hailed the ruling, saying that the courts had upheld the centrality of public interest as an essential consideration where public officials abuse public trust.
Lazima watoke ofisini na constitution ndani ya constitution ndivyo ilivyosema.
It is now back to the drawing board for Lenol Kulal, Waititu and Sonko, with sources close to the governors revealing that they might now seek interpretation of the Supreme Court. Shukri Wachu, K24 TV.